and stands up and instead of telling the House what is out of order, starts attacking his chief or his DO on a matter that happened at home during the weekend. And the Speaker will always ask, what is out of order? So the most abused phrase in the House is always point of order. Everybody shouts point of order, but stands up and doesn't say what is out of order. We will encourage you, honorable members, that when you shout point of order, which is your right all the time, and the standing orders say when a member calls out order, he or she must be listened to. So when you say point of order, I will encourage you to stand up and say, the Honorable Kimani Ichung'wah has breached this standing order, so I seek a remedy from the chair. The Honorable Robert Mbui has breached this standing order, so I seek a remedy from the chair. It will make our debates very colorful, very, very informative, and very helpful, so that we don't just abuse the word and the phrase point of order. Honorable members, as you embark on learning, I want to reiterate what my dear lady, the Deputy Speaker, has said. 5 years look very long, but they are very short. The moment you are elected, the party that sponsored you has expectations on you. The people who campaigned for you have expectations on you. The people who voted for you have expectations on you. The House of Parliament itself has expectations. The country has expectations. And you may end up being spread too thin, and by the time you go back, you find the ground has shifted, as is commonly said. There are many, many members in this House who are personal assistants to former MPs, who are managers to former MPs, and who are, some even who are clerks of former MPs. And because they help to shift the ground, they end up being the replacement to the people they work with. So I want to encourage you that for longevity, consistency of leadership, we also must have a House blended with veterans and newcomers. So you find your way to fight to the corner of veterans like Duale, like Kainan, like Shakil and others, the better. If I don't mention you, it doesn't mean you are not a veteran. Those of you who have been there for 3 terms qualify to be called veterans. I don't know what those who have been there for 6 terms like me will be called. Honorable members, as you embark on your work, I want to encourage you also not to forget the people who make you what you are. You are all family members. Please don't come to Nairobi and forget your families, because it's your families that help us build great institutions in this country. We have a session towards the end where we'll have some experience from spouses of female MPs and male MPs to tell you what the expectations are, how you conduct yourselves with the newfound space, with the newfound accolades, with the newfound opportunities. I encourage you, those of us who come from the countryside, I met some colleague who told me, you know, I've just come to Nairobi, I don't even know where to stay. I don't even know where to start. I told him, you will soon find it very easy. Just go to Parliament, find our staff. They'll show you how to get your mortgage, how to get your car, how to get your everything, and things will work very well. But I added, every weekend, try to go home, so that people don't think they elected you and threw you to Nairobi, and by the time you go back after 5 years, you find the ground has shifted, because it is always shifting. Honorable members, Parliament will avail you, particularly the new members. There's a mortgage scheme. Don't wait and take a mortgage in the third year, because it will be very difficult to service. Take the earliest opportunity to take your mortgage now as the cheapest mortgage on the market. I think it's 2-3% interest, and buy yourself at least an abode where you can be able to operate from. The administrators of our House and Parliamentary Service Commission will facilitate that. I heard you express anger when my dear lady, our clerk, mentioned the SRC. I want to assure you members that this morning, the reason we came a little late, I was having a meeting with SRC on your behalf. And we have called them to order on a few things. And we believe that before we finish this induction workshop, I'll be able to make several pronouncements on your privileges and your other desired facilities for you to do your work. I can assure you, members, there is a book I read by an Irish priest with a title, "It is not always like this." So it's not going to be always like this. Things will be okay. We live incrementally. We don't live by reduction. Nobody in their right frame of mind will interfere with your car allowances, with your mileage reimbursements, and with your mortgage and everything else that you have been having, because that is your entitlement. And as your speaker, I'll ensure that we engage positively, and we have advised SRC that they are not frustrators but facilitators of members of parliament to do their work well. So Sarah Kyoka, our clerk, just suffered what in law we call transferred malice. You aimed your malice at her when it's supposed to go elsewhere. But all is well, members. We can assure you that nothing will change, and if anything changes, it will not be substantial. We want to make sure that members, like the veterans, will not feel the pinch because somebody is shifting goalposts against you. So SRC will be engaged fully. I've invited the chair. She will be here, but she will come after I have made the communications I have told you. Honorable members, as we start this new session, I want to also reiterate what my deputy has said, that expectations on you are huge. A member of parliament in your constituency, you are a funeral undertaker, you are a midwife, you are an extension officer in farming, you are a vet, you are a counselor on social issues. You literally do everything. And above all, you are also the local ATM. Yes. So my leadership will ensure that we facilitate you to discharge some of these unexpected demands from the public. Lastly, I want to encourage all of us members that this induction workshop is important for all of us. The veterans, please be available to our new colleagues. Our new colleagues, please approach the veterans where you are not sure of what you need to do. Our parliamentary staff are all here ready to work with all of us. You will require some of you to sponsor bills in the House. We have some of the best draftsmen and women in the House. You don't have to go and hire any professor at the university to draft a bill for you. We have staff that will draft the bills for you for free. You will not pay them. They're paid by Parliamentary Service Commission. And a good legislator must go down in history as having done some legislation. So whatever you want to do, I remember in the Senate, my distinguished colleague from Kitui brought a bill that nobody expected, a Ndengu bill, to entrench the growing marketing of Ndengu into law and to create a marketing structure and value addition. Even if you come from an area where you grow simsim, you can legislate about simsim. Even if you come from an area of miraa, you can legislate about miraa. There is no limit on what we can put in legislation to bring order in our society. Remember that you are carrying the expectations of 50 million Kenyans. And I want to encourage us. Let's not be in the media for all the wrong reasons. Let's be in the media for all the good reasons. I encourage us not to be in the media because we were shouting at each other in the lawns of Parliament. I want us to be in the media because we have brought a law that is going to bring hope and a smile on the faces of Kenyans in whatever area. Let's not be known and be in the media for reasons that you did this that is unpalatable. Even if you're out of Parliament, you are still a member of Parliament. The badge of honor is not taken off when you come out of the house. You carry that badge of honor whether you are in a social place, whether you are at a marketplace, whether you are in a rally, and as your speaker for this Parliament, I will be your first and last line of defense in whatever way I can to make sure that as members, we will not agree or align but to railroad you, but we will also not allow ourselves to load over Kenyans in a manner that is not consistent with our expectations. With these few remarks, ladies and gentlemen, I want to encourage us that life is a learning curve. Everybody has something to learn, and a good idea will always give way to a better idea. And the best idea will always replace a better idea, and that is part of life. Those who know, don't be arrogant to those who don't know. You know, Mwalimu Nyerere was once asked, what is the difference between mubumbavu na mujinga? And he said, you know, mujinga ni yule hajui. Akijua basi, shida imekwisha. Mubumbavu, hata ukimwambia nini, anabaki tu mupumbavu. So, kutojua ni ujinga ambao si ugonjwa. The moment you know, ujinga inakwisha. Lakini mpumbavu hata ukimwambia nini, unamaliza nasema, what were you saying? You know, there is a joke of a person who rushes to a doctor and says, doctor, I have a very serious problem. Every time I think of something and I want to do something, within a few minutes, I have forgotten. Then the doctor asked him, exactly how long have you been having this problem? He asked the doctor, which problem? So with those few remarks, honorable members, I wish to declare this induction workshop officially opened. And yours truly will be here for the next 5 days with you in each and every session, so that we get to know each other, we get to bond, we get to work together. And anytime you have an issue, the office of Mr. Speaker is open for anybody and everybody. Don't hesitate that because you come from a different political formation, I am here to serve each one of you equally. And doing so, I will. Thank you, and may God bless us, and may we have a wonderful 13th Parliament.
Honorable members, as you can see from our program, we were supposed to have a health break between 10 and 10:30. It is now 11:20, and therefore it is proposed that we continue without a break and then take the lunch break. And in the parliamentary way, I wish to put the question that we continue without a break. In as many as are of that opinion, say aye. Aye. The ayes have it. I deliberately skipped asking for the nays. Luckily, I'm not on the chair, so I can get away with breaking a few rules. And so it is now my duty to introduce our presenter for this time, who will make a presentation on the overview of the mandate and functions of Parliament and parliamentary powers and privileges. I wish to introduce Dr. Elisha Zebedi Ongoya. Mr. Elisha Zebedi Ongoya is a lawyer by training and profession, a legal practitioner in the firm and a partner at the firm of Ongoya and Wambola Company Advocates, and a teacher of law, a senior lecturer at Kabarak University School of Law. He is also a public policy analyst, author, and a critic with a keen interest on issues of good governance, the rule of law, human rights, constitutionalism, and democracy. Dr. Ongoya holds a Master of Laws degree from the University of LLM and a Bachelor of Laws degree, LLB, from the University of Nairobi. He has a diploma in law from the Kenya School of Law. Mr. Ongoya is a member of the Law Society of Kenya, a distinguished one, and the Chess Access Alumni Association. And my claim to fame and honor is that I taught Dr. Zebedi Elisha Ongoya at the University of Nairobi Law School. Not only was he my student, but he was the top student. Not only was he my student, he was ranked as the top performing moot court presenter in the All Africa competition, where he emerged the African champion. I was his team coach. Also, he was ranked as the top 100 lawyers in moot court, performing in moot court in the entire world. To be top 100 in the entire world is no mean feat. He forgot to put that in his CV, so I decided to edit that. So it is my honor to introduce you Dr. Elisha Zebedi Ongoya, and this is a clear case of the student becoming better than the teacher. I'm greatly honored.
Thank you so much, Mheshimiwa Gladys Boss, for those remarks. Allow me to begin by acknowledging the Speaker of the National Assembly, the Honorable Moses Wetangula. We were reflecting with Judge Musinga what we have to call those who have served for 30 years. You know, when you say 6 terms, it sounds short. Until you convert and it becomes a third of a century, that it occurs to you that this is real service to society. Allow me to also acknowledge the acting clerk of the National Assembly, Ms. Sarah Kioko, and the Deputy Speaker, Honorable Gladys Boss, and Mr. Justice Musinga, representing the Chief Justice of the Republic of Kenya. And all of you members, I greet you. Good morning. It is my pleasure to talk to you on this occasion of your induction as members of the National Assembly. And before I get into our today's conversation, allow me, like everyone else, to start by heartily congratulating you on your election as members of the National Assembly. I say hearty congratulations because I'm a student of politics, but an armchair student of politics. You are real students of politics because you deal with politics on the ground. So allow me to share with you my experience as an armchair student of politics as well. Yes, no, heroes must arm themselves with steadfastness of heart, which can brave even the crumbling of all hopes. This is necessary right now, or else men will not be able to attain even that which is possible today. And Max Weber has reflected heavily on how to convert politics from a seasonal engagement, as happens to some of us who come to politics for one term and retire, to those who engage with politics as a vocation and live off politics throughout their lifetime like any other career. Allow me to also thank your staff, starting with the acting clerk of the National Assembly, Mrs. Sarah Kioko, under whose signature I'm here today. I received tremendous support from the office of the clerk, including staff such as Jeremiah Ndombi, Daniel Mutunga, Esther Nginyo, and Japhet Mudomi. I said I must mention them for their support to me because as I stand here, I was very humbled by their support, and I can tell you as members, both old and new, that if these are the support team that you have, then you are up to a good working environment. We must appreciate that. Allow me to make a disclaimer, nevertheless. I am not a parliamentarian. I have never been a parliamentarian. And I was sharing with my very good friend, Justice Musinga, that I did not even have ambition of being a parliamentarian. So what I have experience in is teaching and practicing the law. So what I'm going to offer you this morning is the lessons I have derived out of teaching and practicing the law, and I regard myself as a career student, and one of the areas I'm a student in is the parliamentary practice and the parliamentary processes. You'll be surprised. I watch virtually all parliamentary proceedings on YouTube every day. I don't fail to watch any parliamentary proceedings. The only other parliament whose proceedings I watch with similar enthusiasm is the South African Parliament, because of some of the things that happen there. I was telling a friend of mine that if you want to accuse our parliament of being noisy, at least watch the South African Parliament just once, and you'll be extremely accommodating of our parliament. So, in my experience as a teacher and practitioner of the law, I have learned that there are two realities about life. There is how people are supposed to do things, the theory of doing things. Then there is how people actually act in practice. So the framework of law and rules prescribe a certain way of doing things. But oftentimes when we are on the ground, we discover that things happen maybe not always in full accord with the dictates of the regulatory framework. And I can understand why the designers of this training program designed it as it is, to bring in a teacher of the law who reviews the rules and the regulations and says, this is the framework of rules and regulations, and to also give you an array of people who have actual practice in parliamentary practice or in the economy to tell you this is a reality that you are going to confront. And I think the remarks by the Speaker of the National Assembly tell us exactly that there is a way things happen that you'll need to acquaint yourself with. And I was impressed by the remarks by the Deputy Speaker, Madam Gladys Boss, that adopt somebody, at least adopt somebody and mentor them. Maybe that's an integral way of beginning to write your legacy. If no one else says something positive about you, the person you mentored will remember one day to speak at your final rites and say, he or she mentored me. So that is important for me. Why is it important for us to engage with rules? I'll give you my own experience as a legal practitioner. I'm a stern trainer of lawyers. I train lawyers, and I'm very stern in my training of lawyers. And I do that because the easiest way lawyers do things is through use of precedents. So if I get a question on an election petition that some of you are facing now, I call the Honorable Wetangula and ask, did you ever handle a petition in 1988? Then he says, yes, I did one, and he gives me a copy. Then I copy and paste what he has done, changing the names of the parties. The danger with that is that the rules may have changed in 2017 as they did, and I may be practicing the law as it stood in 1988, perfectly so, forgetting that the earth has shifted beneath my feet. So engagement with the rules themselves becomes an important attribute of the learning of the practice of the law. And so, I think, is your experience as parliamentarians. You have come from different fields, and probably you have served under the tutelage of a member of parliament before, and you've seen how he does things as a manager of a CDF office or something like that, or you've come from different other professional sectors. But parliament has rules governing each of these themes that I'm going to engage with today. It will be important that we familiarize ourselves with those rules, then we familiarize ourselves with the practice as we see those who have been there before us doing it, then the mixture of the two will produce an even better brand of us. My instructions are to speak on the following thematic areas. One, the history of legislatures and the place of the legislature in the constitutional architecture. Close related to that is the functions of parliament, that's the National Assembly and the Senate. Then the performance of core duties of a member of parliament and its relationship with the public trust. The roles of the leader of majority party or the majority coalition, as well as the roles of the England, King Charles I, and the House of Commons. So there was a very bad relationship, as at 1642, in the 17th century, between King Charles I and the House of Commons. So King Charles tried to arrest 5 members of parliament. And I'll be discussing something called parliamentary privileges, because this is the origin of what you call parliamentary privilege up to now. Parliament at that time was very critical of the rule of King Charles, including his taxes, the wars he fought, sometimes his refusal to call parliament to meet. Some people believed that actually Charles wanted to destroy the Protestant religion, which was very critical in England, by virtue of these acts. So there were 5 members of the House of Commons who drafted a protest, what is sometimes referred to as a remonstrance against the king, listing the complaints that Parliament had against the king. Now, if you know the history of the royalty in England, this was actually treason. So they committed what was actually treasonable at that point in time. And this was the first time, 1641, when Parliament openly challenged the monarch. So, accompanied by soldiers, the king himself entered the House of Commons to arrest those 4 characters. But they went into hiding. The speaker at the time is documented to have been a man called William Lenthal. He refused to reveal where they were hiding in Parliament. I don't know the chambers of Parliament, Mr. Speaker, but I am hoping that there are dungeons where your members can hide sometimes when that happens. This must have been the case. So, the king ordered the speaker to disclose where these 5 were. And the speaker answered, "I have neither eyes to see, nor the tongue to speak in this house. But as the house is pleased to direct me, whose servant I am here." Sometimes, many of you will discover there's no quorum in the house. And the speaker will continue conducting business in the house until you raise the point, because of this tradition of 1641. I have no house to see, nor tongue to speak, except as directed by you, the members, who are the servants that I have to serve here. So that conflict between of course, the king concluded that the two must have flown out of Parliament. That conflict resulted into the Civil War, and that Civil War was fought until 1689, when there was a Declaration of Rights. That Declaration of Rights acknowledged Parliament's independence. And among the content of that Declaration of Rights was the right for free speech and frequent meetings by Parliament. What you call today parliamentary privileges and immunities are deemed to have their origins in this historical event of the 17th century, and we have them up to date. We benefit from them up to date. Allow me, in the interest of time, to fast track my thoughts to the history of our parliament in the Republic of Kenya, which borrows now from some of these practices. Again, what we call parliament today, the National Assembly and the Senate, traces its Kenyan ancestry to an institution that was called the Legislative Council, the LegCo. And you remember, I'm happy the speaker spoke about the late Martin Shukuku, former member of parliament for Butere constituency, who spoke very passionately about his experience with the LegCo, because there is something about living through history, and he lived through part of that history. The LegCo was established in this country in 1906, following the promulgation of the East African Order in Council. It held a new constitution, and in that constitution, we create a bicameral chamber once again, for reasons I'm going to come to in a short while. In between that period, a number of things happened. For example, the numbers of representatives in that assembly keep growing up to the number 210 in the run-up to the 2010 constitution, and the number 290 elected as a consequence of the 2010 constitution, and the multiple nominated members who bring it to the 349 for the National Assembly and the 67 for the Senate that we have today. So briefly speaking, that's an overview of how our parliament evolves. We then must speak of what is the mandate of that house. In historical terms, power in many ancient societies was vested in the monarch only. We've seen that in the UK. If you study many other societies, France included, you'll find that is the origin of power. And I'll deal with the question of power and deal with the question of function simultaneously, because the two go hand in hand, as I was taught by my very good teacher, Justice Jackson Boma Ojwang. The nature of fused power is that it is very easy to abuse. Scholars like Baron de Montesquieu have argued that when you fuse all the functions of the state into one and the same body of hands, everything comes to an end. You can't guarantee liberties, you can't have responsible use of power, and so forth and so on. So this French philosopher, who coincidentally was also a speaker of the French Parliament, Baron de Montesquieu, wrote an interesting treatise called L'Esprit de Loi, the spirit of the laws. And in the spirit of the laws, he created a three-legged stool, a stool with three legs. And he said these three legs represent the powers, the functions of the state. It will become impossible. So the proper functioning of the state then requires that each of those three legs are properly working, properly functioning, and discharging their mandate. It is in the context of that that I want us to look at the general mandate and roles of Parliament and of the members of Parliament. Broadly speaking, we can say there are three: representation, whether they are your people who elected you or the special interests that you are nominated to represent; legislation, and I thank God the speaker has mentioned it here today, that it's a very good thing to have your name associated with a particular legislation. And let me tell you something about parliamentary practice as I studied. The Westminster parliamentary practice, which we borrowed from, has a very good tradition. If you sponsor a bill through the House, that bill has its formal name, both in its long title, that place you see saying an Act of Parliament 2, then it says what it wants to do, the long title, the short title, I can say the Traffic Act. But it also assumes your name. You come across things called the Njoki Bill, for example, the Donde Bill. So the Westminster practice has a way to, we honor those who lead important practices in the houses of representation. which is the same thing that if we set up a special committee of the House and appoint you the chair, that's an important honor that the report of that committee goes with your name as well. It goes, so you have the Mwangale committee, for example. So these are important practices that help you as members of parliament to immortalize yourself. Because long after you are gone, your name lives on through permanent parliamentary records. Another important thing is just the tradition of parliament keeping a Hansard, a verbatim record of what you say, where even when you mumble, the staff would capture it and say mumbles, and we will forever know you mumbled. So there's a permanent record, and therefore you have an opportunity to immortalize yourself through the parliamentary process. It's not like minutes of a meeting as we know it, where the secretary may omit some of the things you say. The parliamentary practice is so designed to make you immortalized. And therefore, the only thing standing between you and your immortalization is yourself. If you don't seize the moment to be the face of a particular bill in the House, sponsor it, or be the face of a particular committee report in the House, or be the speak in the House, so that you are documented in the Hansard and you are accordingly immortalized. Having said that, and before without going to regurgitate all this, there are some reminders I want to make. Number one, you sit here as a member of parliament. That's the office you hold. But by virtue of being a member of parliament, you are a state officer and a public officer. Again, you are a person and a citizen. You are also a voter. So you remain a college of all these attributes throughout your membership to this important house that's sometimes called the August House. Your role, therefore, as a member of parliament is inclusive of the obligations of a person, the obligations of a citizen, and the obligations of a state officer and a public officer. Your duties, therefore, must be understood in that context, that your duties as a member of parliament include the duties of a person and the duties of state organs, because parliament is a state organ, working through its guiding soul and consciousness, who is you, the person. Then the duties of voters, the duties of citizens. Among the overriding duties, as I could pick them, is Article 3 of the Constitution. It is the obligation of every person to respect, uphold, and defend the Constitution. Every person has an obligation to respect, uphold, and defend the Constitution. If I had time, I would unbundle what these concepts mean in human rights parlance, and there's a reason why the drafter uses them separately. They don't mean one and the same thing. If you go to Article 94 of the Constitution, it specifically obligates Parliament to protect the Constitution and promote the democratic governance of the Republic. To protect the Constitution and to promote the democratic governance of the Republic. Those of us who either do not sit in Parliament or don't yet have an opportunity there or have no ambition of sitting there will nevertheless, while sitting outside there, judge you against these standards and these parameters. When you say something, we shall ask, to what extent is what you are saying fostering the obligation to promote democratic governance of the Republic? To what extent is it protecting the Constitution? If you look at Article 21 of the Constitution, it provides that it is a fundamental duty of every state organ, I'm just picking that one because I've already categorized you as a state organ, being Parliament, to observe, respect, protect, promote, and fulfill the rights and fundamental freedoms in the Bill of Rights. Of course, for you as legislators, the easiest bit, my friend used to tell me that it's not possible for everyone to do everything. And therefore, if you are a carpenter and you are holding a hammer, when you see a problem, you just see it's a nail. You want to hammer it. That's what you do every day. For me as a lawyer, when I see a problem in the governance realm, I keep asking, can I draft a pleading and take it to Judge Musinga and see whether he can pronounce himself on it? That's the tool for me that I would use easily. For you as a legislator, you have powers, we have said. You have legislative power. You may say, is it possible for this problem to be resolved by law because I have legislative power? Or is it possible for this problem to be resolved by a question? And questions play very important roles. I'll just take a minute to address that so that you understand the significance of just a question. Sometimes, we always underestimate our powers. Sometimes. When I was fairly young in practice, this is my experience with Justice Musinga many years ago. I had not mentioned this to him, but I have to say it. He was a judge of the High Court, and I was a junior lecturer at the Kenya School of Law. So one day, I left class at the Kenya School of Law and saw a lot of noise on Mtandao, isn't it? That the President of Kenya had just appointed the Chief Justice, nominated the Chief Justice, the Attorney General, Director of Public Prosecutions, and Controller of Budget, just alone. So I know Honorable Abdulswamad remembers that episode. And there was a lot of noise. People were calling press conferences at Parliament and declaring that is unlawful. Others calling press conferences and praising it. And I remember a friend of mine called me and asked, Mr. Ngoya, are we completely helpless in this situation? And if you live in a society like ours with multiple challenges, it is very easy to regard yourself as helpless. It's very easy because the problems are many. From the ones the speaker mentioned, the people thinking you are the undertaker, to the source of all food in the village. Villagers wake up to come to your house to eat food, to a local ATM, even in villages where there are no ATMs, and so forth. You may think this is just too much. So I asked her, you know, for me and you, she was a lawyer. For you and me, we only have one tool. Some of us can't go to the streets, just natural. It's not everybody's strength, so we can't go to the streets. If you call a press conference, some of us are not that popular. The media will not even come, so we can't even read a press conference. So what do we do? I said, but you and me have a voice in court. If you sat with me tonight, and we prepare something called a petition and went to court, somebody will hear us, number one. Number two, we may win or we may not win the case. But my very good teacher, Feroz Noroji, had taught me years earlier that you don't go to court to win cases all the time. Sometimes you go to court because court is a platform. When you speak, people listen. So that media, which if you call a press conference cannot come, now will be in court, listening to you and telling the public what you are saying. So it's just the platform. So we prepared a petition overnight. The following morning, we were before Judge Musinga. I remember many questions he asked me. I don't say them here and now because he's a friend of mine. And he told us to go and serve the Attorney General and come back at 3. We served the Attorney General, came back at 3. He gave an interim order stopping any further processing of those names, so Parliament could not deal with those names. We had injuncted Parliament. We are very bad people sometimes. We injunct Parliament. And the following day, the President came and recalled those names. So we kept asking ourselves, is it that easy? I mean, it is very easy to be impactful as a citizen so long as you regard the little privilege society has given you as important. So, what I'm saying is this. Many times, there are people in your village, and I trust you know this, and please don't begrudge them. It is not for no reason that your villagers believe you can solve all their problems. It's for a very good reason. Our socio-economic structure is very fragile. And it has a bulk of vulnerable men and women, vulnerable people, who do not know where the next meal will come from. They are part of that audience. So, they can't go to court because court has filing fees and the procedures for getting exemption are convoluted and the lawyers have become too selfish so they can't take up their matters pro bono. So, the next person is Mheshimiwa. At least Mwananchi knows he gave you his vote. So, you can't do much about it. So that is the atmosphere you are in. And therefore, you come across, such people have said are vulnerable, they can easily be abused, they are often abused. So you'll come across a chief who is abusing citizens through simple things. He can't give them burial permits. It's a simple piece of paper that they require to bury their dead relative. Those people fear hearing their names mentioned by you in parliament. If you just mention that I want this question answered, Mr. Ongoya, chief of Esrabe village, why is he doing ABSD? He will immediately issue that burial permit. You see, you have solved the problem. So don't take for granted the power that you have. The power that you have does not lie in you, thank you, doing philosophical things. Don't scratch your head so high that you want to make an economic recovery strategy law as a person that will make Kenyans owing to other countries to come from 10 trillion to nil for you to be remembered. Some of us will remember you by the very simple question that made the village primary school headmaster stop chasing away children from school. That is the power that you have. It is immense power, good people. Remember this. The Deputy Speaker mentioned it. 50 million Kenyans, only you have an opportunity to stand in that chamber and ask that question. 349. I mean, I'm not a very good mathematician. That's why I studied law out of an engineer. But those of you who are mathematicians, what percentage is that? 349 or 50 million? It is what we call in statistics negligible. You hold such a privileged position that if I have to have any sway on your behavior and your thinking, it is to constantly remember that you are that important. To constantly remember that you are that important. I tell this to judges of the Supreme Court. I tell this to Court of Appeal judges, because if the whole country, 50 million people, only 29 or 30 of you are Court of Appeal judges, that's an extremely privileged position. You must use it very responsibly. Allow me, so I don't take much time, to just remind you one thing. You'll remember the oath you took a couple of days ago. It obligates you to obey, respect, uphold, preserve, protect, and defend the Constitution. I think that summarizes it up for me in your obligation number one. We are all human beings, and we all sometimes fall short of expectations. But I think what is important for me is not whether or not once in a while you fail short of expectations or people perceive you to be failing short of expectations, whether at your heart of hearts you have committed yourself to be able to discharge your functions under that Constitution. The power that you exercise is also public trust. And you can see that in your oath of office. You promise in that oath to bear true faith and allegiance to the people in the Republic of Kenya. That's the trust that you carry with yourself. You look at Article 1. That power belongs to and is derived from the people of Kenya. If you look at Chapter 6, Article 73, that power is a public trust. Then more importantly, Article 94, it says the legislative authority of the Republic is derived from the people and at the national level is vested in and exercised by Parliament. Now, those of us who are commercial lawyers know what we call the principal-agent relationship. It means the source of the power is the principal, the people. But you are the agent. You are the trustee. Then it also says, so that's the lawmaking power. It says, Parliament manifests the diversity of the nation and represents the will of the people. Allow me to just, in closing on this chapter, reflect a little on the law on trust. The law of trust generally, which then binds you as a trustee, obligates every trustee to do the following. One, to act in the best interest of the beneficiaries all the time. To ask who are the beneficiaries under this trust and to act in their best interest. Two, to exercise reasonable care and skill. Reasonable care and skill. To avoid conflict of interests. And not to profit from the trust. And to act in good faith and with honesty and integrity. and to comply with the terms of the trust document, and at all times to inform the beneficiaries of their position and to provide such information concerning the trust as the beneficiaries are entitled to. Some of these things can be legislated. Some of these things cannot be legislated. And let me tell you, you cannot legislate good manners. So speaking as a voter and as a citizen, I will also be beseeching us to act as men and women of good manners all the time. I've mentioned oversight. Oversight is important and it takes multiple forms. You begin with powers of the High Court, for example, to summon witnesses. That's immense power. Summon witnesses, and they have obligation to come. Whether you do it in camera or in public, imagine yourself just before you are once elected to parliament. Imagine yourself when you met a police constable, the OCS, or the Inspector General of Police. I grew up in the village myself, and I saw our people had a relationship of the police with the police that was very funny. Whenever they saw a policeman, they began running away, because meeting a policeman was tantamount to engaging in uncalled for trouble. And probably you were in that category some time back. Today, you can summon the Inspector General of Police, and he comes. I mean, that's immense power. That's oversight power. And I've told you, it comes from such sophisticated manifestations to simple manifestations of just asking a question. People fear hearing their names mentioned in Parliament. So I'll not want to dig so deep in that in the interest of time, but let's reflect on those things. Enacting legislation is an important function that we have, and they deal with everything. Speaker has mentioned it here. You can legislate Andengu law. You can legislate on that problem affecting your people. You can legislate on it. You can draft a bill around it and legislate on it and provide a framework for solution of the problems for your people. I speak as a mwananchi now. Mwananchi sometimes get very frustrated. Sometimes they hear you complaining. Then they keep asking, okay, if Mheshimiwa is complaining, what does he want us to do? I am enlightened enough to know that although you have power, you don't have all power, and you oftentimes get just as frustrated as I do. But my grandmother in a Sarabe village may not understand, and yet you also represent them. So they expect you to complain less and craft solutions a little more, and we better keep that at the back of our mind. To discharge your functions properly, you will need very good relationship with your sister house, the Senate. And let me tell you, you are very privileged. You're extremely privileged because when the Senate filed a case in the High Court to challenge certain behavior of the National Assembly, I was retained by some of the NGOs that were involved in the matter to represent them, so I was present in the case. And today, the member of the National Assembly, the member of the Senate, the then majority leader of the Senate, minority leader of the Senate, that advanced that course is your speaker here. It is important because of what I've said elsewhere. I know there's a topic here on diplomacy. I keep telling people diplomacy may sound like a very sophisticated thing, but all diplomacy is very personal. It's just about how people relate personally. And the speaker has said in my hearing, he has an open door. Meaning, where there were those rough edges, you could actually knock in his door and say, how can we relate better? He knows better what the other side is thinking. So that if you improve your relationship with your sister house, you enhance your capability to discharge your functions. Allow me to reflect briefly on powers and privileges because I consider it to be important. And anytime somebody gives you a function, anytime somebody gives you a duty, an obligation, I was taught in constitutional theory, ask that person to add you powers. Because it is impossible to perform functions without powers. Even when you are a class monitor or a class prefect, sure, you must have the power to write the names of noisemakers down. That's the only thing that enables you to manage that class. So, power is an important enabler to enable you discharge your functions. The only legitimate purpose for which power can be exercised is for the performance of the functions. I say this because the subject of powers and privileges is a subject that has sometimes been controversial. It is important, for example, for you to be able to speak freely in Parliament, speak freely, without the fear that you are going to be sued for defamation. It's important. If you have to look over your shoulder, if you have to measure your vocabulary very clearly, then you will feel hamstrung. So it's important that you are able to speak freely in the House. And therefore, the right to free speech is an important privilege that you enjoy as a member of the National Assembly. And you will derive these powers, privileges, and immunities from the following sources. The Constitution gives you. The Parliamentary Powers and Privileges Act gives you. The standing orders give you these powers and privileges. And the rulings of the speakers of the House give you. It is because, if you look at standing order number 1, the speaker has decisional power. That decisional power is interpretive power. That if there is a controversy about the meaning of the bundle of, the speaker interprets and unbundles those powers. So the ruling of the speaker becomes an important source of reference when you want to know the scope of your powers and your privileges. And I've told you those powers and privileges have significant origins in the United Kingdom. I'll just give you some of the sources for your own reading because time is on my side. If you look at Article 94 of the Constitution, it gives you the power to make law. Article 117 of the Constitution gives you freedom of speech and debate in Parliament. Freedom of speech and debate. I dare say this is perhaps the most important right you have as a member of Parliament. Because those of us who theorize a little as academics say that you can categorize rights broadly into 2. Fundamental rights and instrumental rights. Instrumental rights are equally fundamental, but they are instrumental because they enable the realization, the fulfillment of the fundamental rights. So that your oversight power, your lawmaking power, your representation power is nothing without you being enabled with free speech. I keep telling academics that, we write books, we pontificate, because other people make biscuits elsewhere. In Parliament, you don't make biscuits. So what do? You speak. You discharge your functions through speech. Article 118, which gives you power to exclude strangers from the chambers. And look at that privilege. No one can ever call you a stranger unless and until you so offend the law that the Speaker and his Powers and Privileges Committee decide to deal with you as empowered by law. But whether the Speaker likes your face, whether the Speaker likes your height, he can't do anything about it. You must enter that Parliament and be there. I mean, that's an important privilege. It doesn't matter your political formation. The Speaker can never say once that, I don't like of this political formation. No. And if you follow a political formation in South Africa called the Economic Freedom Fighters, you see what I'm talking about. There are people who can really make noise in there, but they are there and they remain there. Article 124 of the Constitution, the power to establish committees. Article 125 of the Constitution, you will see the powers as they evolve. Then you have the immunities. They shield you from adverse action for proper use of this power. So you'll find the immunities in the Parliamentary Powers and Privileges Act of 2017. It gives you multiple privileges. It gives you multiple immunities, including whether you can be served in the precincts of the House, whether you can be arrested in the precincts of the House, whether proceedings can be brought against you for words spoken or written in a report of a parliament or committee. Allow me to come to something that is important because we may miss it. There are limits to these powers, privileges, and immunities. Why are there limits to it? One is Article 2 of the Constitution. It says, anything in contravention of this Constitution is null and void. So that if you do something that is unconstitutional, then that is null. That is not part of what the enabling law seeks to protect. And I'll share with you just one case that has been determined by our Court of Appeal now. And the Court of Appeal determined this case some time back. The case of Eric Gorsungu versus George Odinga Oraro, senior counsel, you may know him. And many of you remember that there is a death that we are yet to resolve in this country, the death of the late Robert Ouko. Many of you remember there have been various attempts at investigations and inquiries into that death. Many of you remember that Parliament in the year 2003 or 2004 set up a committee to investigate the death of that citizen, and the chair of that committee was a man called Eric Gorsungu. Something interesting happened. Of course, he was chair of a committee, so he's chairing parliamentary committee. He's in parliamentary business. He's entitled to the privileges and the immunities of the House. Then, in the course of the proceedings of that committee, my very good friend, senior counsel George Oraro, was adversely mentioned. And he got his lawyers to write to the committee and say, I now want to appear before the committee and also have my version of the story heard. That committee was meeting somewhere. I'm not certain whether it was Naivasha. I'll cross-check that fact. On a Saturday, the chair of the committee came to Parliament buildings, called the press, and gave a press statement. The press statement read, I can assure you that we are getting to the bottom of this matter, and hence the hula baloo we are hearing outside there. That is why there's a lot of hassle, because they know we are going to find the truth, and the truth we shall find. I do not want to say anything more, but I have evidence, eyewitnesses. There is a concerted effort by people within and outside Parliament, particularly those that have been mentioned, to put some spanner in the works so that this thing cannot go on. And I can assure you, we are not going to stop. We'll go on, and nobody is going to dictate to us in which manner we are going to call witnesses. I can assure them they will be accorded the chance, the opportunity to say what they want to say, and we shall crucify them. So this is the statement that the chair of the committee made in the precincts of Parliament on a Saturday alone, having left his committee somewhere else. George Oraro, who was the one to whom the statement referred to, filed a defamation case. And the issue arose as to whether this conduct on the chair was protected by parliamentary privileges and immunities. The High Court found it was not, and slapped Eric Gorsungu with a bill of 3 million shillings, general damages. Gorsungu appealed. Oraro cross-appealed, saying, in fact, this award is too little. He should pay more. It is true, the Court of Appeal agreed with George Oraro and enhanced the damages to approximately 9 million shillings. I'm giving this case so that what I'm speaking here does not come across as abstract. It is real, that we need to reflect on the scope of powers, privileges, and immunities, and to act in accordance with the scope of powers, privileges, and immunities. I say this because of a number of questions that I want to ask without proffering answers. First, I know that the nature of political processes is that they can raise tensions quite a bit, and we see it both in Parliament and outside Parliament. That's the nature of politics. The nature of political processes is they raise tensions. They raise temperatures sometimes. But that does not suspend Article 73 of the Constitution that decrees that the manner in which you use your office must bring honor to that office. Allow me not to use the National Assembly or the Senate, but use the example of a county assembly of my home county of Kakamega, where members of the county assembly want to remove the speaker. And sometimes they get very frustrated. I don't know why. I keep asking them, but you have the power to remove him. Just go and vote. Even vote quietly. He will leave. Once the vote has gone. When I train judges or magistrates, I keep reminding them that, no, you have power in your pen, isn't it? So don't shout at me. Just write down. Just write down Ongoya is now imprisoned for 3 years. I have to go to jail. You don't need to shout at it at all. So they were so frustrated by the speaker, they decided to remove him in office quite literally. You know, removal became quite literal. So you go to the office and carry him out. Removal. The word was understood quite literally. And of course, the speaker closes himself inside the office, and they take machetes and break the office. There's a book I used to read called The Government Inspector by Nikolai Gogol. There was a teacher called the history teacher who taught his students Napoleonic Wars. And the only way he taught them how Napoleon used to fight was by picking classrooms and chairs and throwing them at the students to teach them how Napoleon used to fight. So people keep wondering, but no, those chairs are government property. You are breaking them. That door you are breaking is government property. How immune are you from the law on malicious damage to property, where you are captured actually breaking doors and so forth? I don't know whether it happens nowadays, but I think it was in the 7th or the 8th Parliament, Honorable Tangula would remind us this, when the struggle for the mess was always real. People would run for the mess itself. I don't know what material makes that mess, but I suspect it's of value. If you broke it, I don't know whether you will enjoy privileges against a criminal charge of malicious damage to property. And another thing that I must mention as I talk about this is wealth declarations. Wealth declarations. The law requires all public officers to declare their wealth to certain responsible commissions. I trust we know that. We are the lawmakers. I don't get into the details of that. And it requires us to make an inception declaration. I am sure you have already declared, or if not, the clerk and her staff would guide you in making the inception declaration. When you come in, you must declare what you have, because that becomes the checklist of what you have assembled as you go out, and responsible institutions may ask, in appropriate cases, ni mvua gani ilikunyeshea in the last 5 years. It also requires you to declare that wealth at intervals of 2 years. And as you exit, to also make an exit declaration. Now, failure to comply is an offense. Failure to comply is an offense. And I know that the people who actually do the coordination and the receiving of these documents and perhaps following up on you are parliamentary staff. And there is something about when you are an officer in a department dealing with the senior most, the board, so to speak, there's a way in which the respect borders on fear. So they may not push you so hard to do it. But the question that arises is whether your privilege goes to that extent. I want to say that it is always good to live a secure life because of the transcendent nature of power. That no one may do something about it when you are still wielding power and you have some use, but somebody may take some action against you when the power is gone, and therefore it's only fair that you confirm that you have complied. The point I'm emphasizing in all these words, ladies and gentlemen, is that we have power, we have privileges, we have immunities. But that power is not absolute. Those privileges, although sometimes regarded as absolute. They are only absolute in particular parameters. Once you go outside those parameters, you may find the law visiting you for that purpose, and you may find it difficult to unwriggle yourself out of it. The other option is you may only wriggle yourself out of it with the help of a lawyer, and that is sometimes extreme cost. I say so because I'm one. Let me close by just reflecting briefly on the two critical offices that I was told to make mention of: the office of the leader of majority party and the office of the leader of minority party in the National Assembly. In reference to the National Assembly, these offices are expressly referred to in the Constitution, and therefore they are important offices to that extent. Now, it's important to understand the structure of our Constitution at the moment. Our Constitution created a significantly presidential system of government. When that happens, it means that you vest power in the executive and create institutions of check. Immediately that happens. So you have the executive sitting outside there, but you create parliament as a check to that institution. So this constitution created two offices, the leader of majority party and the leader of minority party, to substitute the offices of what used to be the leader of government business in the House and what used to be the leader of the official opposition in the House. These offices are important because, as I would say, number one, they are mandatory members of certain committees of the House. When you go through the committee works, I'm certain that you will get over that. If you get, and I don't want to get into the current politics about which party is the majority party and the minority party, that the speaker will deal with. You are very privileged to have the speaker that you have today, because not only is he learning decision making from the House, he served as a magistrate. So he has already been inducted into decision making by the highest decision making institution in the country, the judiciary. The judiciary only makes decisions, and he has served there. I'm certain he is well equipped to deal with that. So the leader of the majority party, therefore, effectively becomes the leader of government business in the House. He brings the government agenda in the House, where the majority party is the party that forms the national executive. He therefore marshals legislative programs of government in the House, schedules legislation for floor consideration, and helps do daily, weekly, and annual legislative agenda for the executive if he comes from the party that also was privileged to constitute the executive arm of government, including marshalling the House to approve nominees to certain state offices in the executive. There are certain offices that you must approve before people take them up in the executive. He must work closely with the speaker and the party whips and consult you members and other party leaders to build consensus. I'm told diplomacy is important to get any agenda moved through the House, and that is important. He's a member of the House Business Committee, as I've said, and the Committee on Selection. He's also a member of the Committee on Appointments. Allow me just to close by looking at the leader of minority. It's also an important office. Remember, I've said it is a constitutional office. You'll find it in the Constitution first, before it's referred to in the standing orders. And among other things, he champions the minority position on issues and debates. He negotiates with the majority party, and again, I've said this. At the heart of all this is diplomacy, is negotiating, making compromises where necessary, and pushing your agenda, sometimes painstakingly, sometimes incrementally, but nevertheless, making progress. He mobilizes the minority party to exercise checks and balances on the government in cases where the majority party is the party forming the national executive and where it appears to play ball quite a bit with the executive, and also marshals the legislative programs and agenda of the national executive in the House, where the minority party then becomes the party that is forming the executive. These people cannot work in isolation. They work in tandem with other important offices in Parliament, the office of the Speaker being the head of the institution, and the whips being other critical role players in the House. Allow me to close as I began by reminding us that we have begun an important journey. We have begun a journey. You know, changing a society's destiny is not easy. all of us in our own small way do our own little things, whether you are a nursery school teacher, to change society's destiny. But sometimes fate and nature conspire and they put you in a vantage position. Now, Martin Luther King Jr. used to say that the arc of justice always, the arc of history always bends towards justice. The problem is, very few of us have a chance to stretch our hands high enough to reach that arc of history. Very few of us. You are among those who are privileged to have stretched your hands, and your hands have reached that arc of history. Let us collectively try to push that arc further towards justice. And may God bless you, and may God bless the Republic.
Thank you very much, Dr. Ongoya, for that wonderful presentation. I think some people are worried that we've taken a little more time on that, but it was a very important session. Our next session is very brief. I think what we can say, what we can take from Dr. Ongoya is that all of you honorable members have the power to speak, and that power to speak can change the lives and destinies of the people that we represent. That you can make a minimum effort in the House by speaking, but you will have a maximum impact on the people that you represent. Now, allow me, honorable members, to present His Lordship Justice Daniel Musinga, who is representing Lady Justice Martha Koome, Chief Justice of the Republic of Kenya, and President of the Supreme Court of Kenya. His topic will be on interlinkages and interdependence between Parliament and the judiciary. Allow me also, Honorable Speaker, to briefly give the bio of His Lordship Justice Daniel Musinga. His Lordship attended University of Nairobi in 1984 to 1987. After law school, he took up a job in a leading law firm as a legal assistant in Mombasa. And in 1999, he opened his own law firm, Musinga and Company Advocates. In recognition of his successful practice, he was elected the chairman of the Mombasa Law Society of Kenya and was re-elected again in the year 2003. Because of his legal prowess, in September 2003, he was appointed by His Excellency, the late President Mwai Kibaki, as member of a tribunal investigating the conduct of certain suspended judges. His colorful legal practice culminated in his appointment as judge of the High Court of Kenya and was immediately posted to Nakuru. Subsequently, he served in various courts, the Kisii High Court, the Constitutional Judicial Review Division in Milimani, Nairobi, and later in the Commercial and Admiralty Division in the High Court of Nairobi. He also served, thereafter in the year 2012, he was appointed as a further promotion as a judge of the Court of Appeal and worked in Nairobi, Kisumu, Nyeri, Malindi, and Mombasa, and now Nairobi. In 2021, he was elected president of the Court of Appeal, a position previously held by Justice Ihara Kariuki, now Attorney General, also held previously, I think your immediate predecessor is His Lordship Justice William Ouko, now Judge of the Supreme Court of Kenya. His Lordship Justice Daniel Musinga has also received awards, one of them being the Law Society Distinguished Service in the Administration of Justice Award. He has also been named by the International Commission of Jurists, the Kenya chapter, as Justice of the Year. He has also served in various committees in the judiciary. And with that brief introduction, I wish to welcome His Lordship Justice Daniel Musinga. Welcome, Your Lordship.
The Honorable Moses Wetangula, Speaker of the National Assembly, Honorable Gladys Boshole, Deputy Speaker of the National Assembly, Honorable Members of the National Assembly, Acting Clerk of the National Assembly, Mrs. Sarah Kyoko, distinguished guests, ladies and gentlemen, good afternoon once again. It is indeed a pleasure for me to join you this afternoon on behalf of the Chief Justice, Mother Kome, who is not able to be here for good reasons as explained to the Office of the Speaker, and who has requested me to share insights about interlinkages and the interdependence between Parliament and the judiciary. Let me start by congratulating all of you honorable members of the National Assembly for being elected or nominated as members of this august institution, which is the pivotal pillar of our representative democracy and the embodiment of people's sovereignty. As the arm of the government responsible for legislation and oversight, Parliament occupies a special place in our governance framework, and being trusted by the citizens to represent them in either house is a high calling for which you must all be proud. Allow me to convey my heartfelt congratulations to the Honorable Moses Wetangula for his election on 8th of September as the Speaker of the National Assembly. I am particularly proud today as the Honorable Speaker of the National Assembly, who served in the judiciary as a district magistrate from October 1982 at the very beginning of his legal career. It is said that the very first job you hold after college is the most important, as it shapes the rest of your career and your life. We in the judiciary are proud to have set the Honorable Speaker on a career path that has seen him rise to the leadership of one of the three core equal arms of the government. Honorable Speaker, we salute you. While we take great pride in the fact that he started his career in the judiciary, it was quite disheartening to learn from the interview the Honorable Speaker did with the Star newspaper in October 2021 that he quit the magistracy for private practice because the salary he was earning as a magistrate could not meet his growing financial obligations. Honorable Speaker, I am saddened to report here that 40 years after you had to leave the judiciary to pursue better prospects elsewhere, the judiciary is still losing some of its finest employees who seek better pastures in other institutions because we are not able to offer them competitive terms due to our budgetary challenges. Now that you experienced the working and challenges of the judiciary at such a personal level, we hope we can rely on you, Honorable Speaker, and the National Assembly under your able leadership to help in our quest for better funding that will enable us to attract and retain highly qualified Kenyans who will help us serve the people of Kenya. Let me also extend my congratulations to the Honorable Gladys Boss-Sholay on her election as the Deputy Speaker of the National Assembly. I am proud of the Honorable Deputy Speaker of the National Assembly, who also worked with the National Council for Law Reporting when it was administered under the judiciary, and later as the Chief Registrar of the Judiciary before moving to elective politics. There is no doubt that our experience as the judiciary's accounting officer and pass holder gave her unparalleled insights into our troubled budgetary position and other challenges which can be addressed by the legislature. I am glad that both leaders of the National Assembly have this history with the judiciary, and we hope we can capitalize on this relationship for the betterment of our respective institutions and the people of Kenya. Honorable Speaker, honorable members, ladies and gentlemen, turning to the subjects of this induction workshop, I was asked to speak to you on the topic of interlinkages and interdependence between Parliament and the judiciary. The appropriate starting point is to appreciate that Parliament and judiciary are two important pillars of our democratic and constitutional system. Under the Constitution, the two institutions enjoy relative autonomy and independence in their respective spheres of activity. Despite this emphasis on the separation of powers, the Constitution, in its architecture and design, demands that state institutions embrace a dynamic relationship so as to work to meet and realize the hopes and aspirations of the people. It is important to point out the reality that our two institutions can best discharge their mandates only with mutual deference for their powers and functions. Otherwise, there is every risk that they will perpetually wage war against each other, therefore negating the constitutional promise of governance as joint enterprise by the three arms of government. The pursuit of this constitutional promise of governance as a joint enterprise requires institutional committee. The ideal of institutional committee can only be practically realized if courts appreciate that the legislative domain is the terrain of the Houses of Parliament, whose members must be given the leeway to legislate. For example, in an important decision by the Supreme Court in the Justice Kariuki Mate case of 2017, the court spelled out the doctrine of restraint that courts should not issue injunctions to stop ongoing legislative processes and should assume jurisdiction after the conclusion of such processes. Similarly, members of the legislature must respect the constitutional mandate of the courts, which is to ensure that all laws and conduct remain within the four corners of the constitutional legality. In saying this, we must always appreciate and bear in mind the fact that we are operating under a supreme constitution. The supremacy of the Constitution, honorable members, as articulated in Article 2 of the Constitution, means that the Constitution binds all state authority, organs, and institutions. Given that the values principles, and rules articulated in the Constitution have normative force and enforceable by the courts. This means that where any state organ acts contrary to these norms, then courts must of necessity intervene to restore the intention of the Constitution. Our plea to the legislature is not to see such judicial intervention as power struggle between the various branches of government. Rather, judicial intervention properly understood is an attempt by the courts to redirect the various arms to proper constitutional channel for the pursuit of their goals. Put differently, to attain the goal of consolidation of democracy requires a strong parliament that discharges its representation, oversight, and law-making roles robustly. However, this does not mean that Parliament should enact abusive laws, fail to oversight the government of the day, and trample upon the rights of citizens, including the vulnerable and the marginalized groups in our society. Honorable Speaker, honorable members, ladies and gentlemen, the engagement between our two institutions should also be pursued in a context that is mindful of our constitutional history. We ought to always remember that both the legislature and the judiciary were often dismissed in the pre-2010 dispensation as insignificant actors in governance. This is because they were seen as being mere rubber stamps for the executive branch. This notion was connected with the widely prevailing perception then that although these two institutions had considerably significant powers under the repealed Constitution, in practical terms, they had abdicated on their mandate, thus did not play a decisive role in governance. We must therefore understand the significance of the coming into force of the 2010 Constitution as an inflection point in the place and role of Parliament and the judiciary in governance in Kenya. This historical context should make us appreciate that ours are still fragile institutions that need nurturing and support to discharge their functions, especially the shared oversight mandate, optimally